You know, Charlie Sheen, new twists in the latest in his domestic case. It turns out that his wife now wants to try to work things out in their marriage.
Yeah, but there's the little thing of that protective order and, allegedly.
And a 911 call that he stuck a knife to her throat, held a knife to her throat, threatened her life.
He denies it.
So here's the question. How much harder will it make it for prosecutors if they decide to go after the TV star? Our legal panel looks at the case.
A complicated domestic and legal dilemma involving actor Charlie Sheen. He and his wife reportedly trying to save their marriage after a Christmas Day brawl in which Sheen allegedly threatened his wife, Brooke Mueller. But if Sheen's wife wants to, patch things up, will that stop prosecutors from going after the TV star on some pretty serious charges? Joining me now to weigh in on the different legal aspects of the case are fine defense attorneys Chip Merlin and former prosecutor Stephen Razor. Good to see you both.
Good to see you, Greg.
Stephen, let me start with you since you're the former prosecutor. I mean, Brooke reportedly wants to, kiss and make up, but she's the one who called 911 claiming that her husband was holding a knife to her throat, vowing to kill her, which he denies again. But look, Stephen, once the criminal process begins, especially in domestic abuse cases, isn't it hard to stop it?
It's not actually hard to stop it, but the point is that it is not up to the victim to make that decision. That is up to the district attorney's office, and that's going to be based on a lot of different factors. Number one, if they believe that she will, in the end, go forward if she's forced to, because theoretically in a criminal case, as most people do understand, it's the people of the state of Colorado in this case against the defendant, Charlie Sheen.
Right.
They can subpoena her. And they could force her into court, theoretically. That doesn't always happen, and therefore they're going to be looking for additional pieces of evidence, such as that 911 call itself.
Chip, even if both sides want to cohabitate, there's that little tricky thing called a protective order, which a judge signed. Wouldn't that have to be modified? And wouldn't her safety have to be physically monitored?
Well, in cases of domestic abuse, you always have those concerns as a court, and they do have to have a modification of that order under Colorado law. What's interesting here, and the real raging debate right now is she asking for this to be changed or modified because she really wants to save the marriage, or is she really looking to make millions out of this, as some suggested, with the change to that prenuptial agreement?
Right. Stephen, she does appear to be backing away from the claims about what happened that night. If she were to recant, couldn't she be criminally charged with making a false police report or even obstruction?
She certainly could be, Greg, but the problem with these cases is that there's a overall policy consideration which is taken into consideration in cases like this. Yes, they could charge her with that if they find that she is recanting and therefore is admitting that she lied initially. Yes, they can go after her, but will they? They'll be afraid of a chilling effect because of how it will affect future victims from coming forward.
Chip, I want to pick up on something that Stephen said earlier. Let's assume that Brooke decides she doesn't want to testify against her husband, which is not, by the way, uncommon in domestic abuse cases. In Colorado, there is the spousal privilege, which, if it's invoked by her, not him, but her, would exempt her from testifying against her husband. I checked it. It doesn't apply in cases of domestic abuse, so she would be forced to take the stand, as Stephen said, right?
Well, you make a great point, Greg. In over 40 states of the union, the privilege no longer applies where the allegation is that there's been domestic abuse against that particular spouse. However, and this is where this whole prenuptial issue comes back into play, is she going to say that I'm not going to testify, and if they even put her on the witness stand, then take the Fifth Amendment? They can do all kinds of various things.
How is she in jeopardy? You can only invoke the Fifth if you're in jeopardy, right?
She'd be admitting.
But you don't know. Yeah, but she doesn't know why. All she's going to do is say, I'm not going to testify because of the Fifth Amendment, and what are they going to do in those situations?
All right,
it's the reason why domestic abuse cases are hard to prosecute.
Let's assume, Stephen, there is a trial, and Sheen's wife becomes the reluctant witness. She doesn't want to testify, or she takes the Fifth. The 911 call and what she told police, all of which is contained in an affidavit. It may be hearsay, but it's admissible under a bunch of exceptions to the hearsay rule, isn't it?
Yeah, the 911 tape especially, that is going to be the most powerful piece of evidence that they have, because there you have her calling at the time that the event occurred. And therefore, just even forget about the legal aspect of it, but just on a common sense perspective from your average juror, they're going to tend to believe that statement more than they would even as to a victim coming into the court and testifying, because they're under the stress of the event. And therefore, the chances of them lying while they're under the stress of the event and not having the opportunity to think about the consequences
it's called
of their
an excited utterance, an exception to the hearsay rule. Stephen Razor, Chip Merlin, good to see you both. Thanks so much.
Thank you, Greg.
Thank you.
And that's